So it's come to my attention that you have not signed the waiver. So there's two options that we have here. You can ask for a bond or you can waive extradition. Once you waive, we give the demanding jurisdiction 14 days to come pick you up. In this case, it's Orange County, Florida. That's where you're wanted out of for grand larceny in the third degree.
For what, sir?
Grand.
Okay, this is where it gets real. The judge is explaining extradition basically. Florida wants her back to face grand theft charges. The defendant can either fight it or waive it, meaning she agrees to go. But here's the twist. Once she waives, the clock starts ticking. Florida has 14 days to come get her. If they don't, she walks. What would you roll the dice or fight it?
Larceny in the third degree.
That means grand larceny.
Larceny is it's a theft.
Third degree is.
As far as, I'm just telling you what they wrote on the actual, on the complaint, it says not grand larceny, grand theft in the third degree, $5,000. That's what it says. So if you do not want to waive, that is okay. The waiving, it speeds up the process because we only give them 14 days.
Notice how the judge slows things down? That's intentional. This is a due process checkpoint. The court is making sure she fully understands her options so she can't later claim she was coerced. But here's where many defendants trip up. Waiving extradition sounds quick and easy, but it locks you into another state's custody. You're not just taking a trip, you're surrendering your freedom to a different jurisdiction.
Days, Harris County releases you. You got to understand, even if we release you, that warrant from Florida will always remain active until you go back to Florida and take care of it. If you refuse to sign the form, that's okay. We will get a governor's warrant, but that takes 90 days. You're going to sit here 90 days waiting for that governor's warrant to hit. So I will let you make the decision with Chablis what you would like to do. I don't want you to.
Plot twist. There's another open felony theft case right here in Texas, which means the extradition clock won't even start until that's handled. In plain English, she's stuck. Even if she signs the waiver, she can't leave yet. This is a classic legal domino effect, one case freezing the other. Ever wonder how people end up sitting in jail months longer than expected? This is exactly how.
Everyone, take your time.
She does want to waive, and they were going to give her the credit for Friday when she was originally booked in. They were going to backdate it to Friday.
Here's the kicker, though. I just noticed you have an open felony theft case, and you've not made bond on that case. So what happens is that 14 days is typically told until you resolve that case or until you post bond. When all the holds are lifted, at that point, that triggers the 14 days for Florida to come get you. So,
I didn't know you had a case.
yeah, I mean, I just noticed it too. So, you can still waive now so that once that hold lifts, it kicks in the 14 days. So, well, I'll let you guys talk about it and let me know.
Yes,
Yeah.
thank you.
All right.
Okay, I'll get the
It's close.
paperwork to you to sign. It just doesn't come into effect until you handle the paper.
So Chablis, if she waives, there's no need to bring her back out. We'll just sign it and then I can sign it and then we're done.
Yes, sir.
Working on Mr. Jonathan Joyal. It's a young man with 2 cases in your court.
Okay, tell me what's going on.
So here's what's going on, Judge. My understanding, and we're trying to confirm from upstairs in felony, is that he's going to WIMAC based on the new violation in your court of a UCW. So that's causing him to be amended up there and go into WIMAC. That being the case, he's currently in custody. He's only going to be released to WIMAC. So at this point, I'm trying to see what kind of options we have for him. I wanted to come to you to see if he doesn't want to plead to this, how quickly can we give him a trial date if he wants to go forward on these cases?
Alex, do we know 100% that they're going to amend and go to WIMAC?
The only note that I have from the prosecutor in felony is saying that the defense told him the defendant is willing to go into WIMAC, but I don't see any clear indication that that's what they're going to do.
The research I've done,
It happened.
the research I've done on the system and on some of the notes on my end, I don't think they could see it, but it says release to WIMAC only. I looked at the activities up there, and based on all the research, it looks like he's going into WIMAC.
Let me see. Maybe I can see something.
I talked to him as well.
Well, I do see on the same day that note was placed, they dismissed the MAJ and just said that there was a condition amended, so it may be that.
It should reflect in the notes somewhere. I can't imagine that one of the
It left
prosecutors is
explanation
gonna.
blank on the motion to dismiss.
Well, no, not, I get it,
Well-
but don't y'all have like a independent notes to, I mean, every time something happens, you guys should notate what
Yes, Judge, and
happened.
the only note we have that says is defense counsel stated the defendant is willing to go to WIMAC to stay on probation. And then they followed that with a dismissal. So I'm
I
imagining.
see it. No, I see
See what I'm
it.
talking
I
about?
see it says, so like I have here 131 amended conditions of probation order, release defendant to WIMAC staff only.
That's what I got as well. That's
Okay.
mine.
Kelsey,
Yes.
what do you want to do with this case? Because we have these two UCWs. While these are open, we can't do.
One UCW, one evading.
Right, I emailed them, Your Honor, and I mean, I need to have confirmation. that
Have you
it's
put an
done.
offer on this case?
Let me look.
Because maybe you can work something out today. I don't know.
He does, I talked to him. He doesn't want to plead to it.
Oh, well, then if they don't want to plead to it and they're not willing to dismiss both, we'll have to set up a
And
trial.
that's why I'm touching base to see how quickly we could go to trial.
You need at least 30 days.
Okay.
So they're going to need at least 30 days to get subpoenas out. So it'll be a minimum of 30.
Okay. Lose a week, right? I lose a week. If we're going off to 30 days, I'm losing a week just by agreeing to this. All
No.
Okay.
So that they, and
right, let me talk to my client and see what's going on. Okay, thank you.
Sure.
Thank you.
Do you want to talk about something else real quick?
You had one other one, and here's the,
Okay, great.
Confirm, since she signed the waiver, we're gonna set her bond at 1,500 for silence.
We're setting the bond at 1,500, right? For,
Gonzalez. Because she came and gave this to me after she signed, but she didn't reapproach with you.
yeah, she didn't say definitively whether. Yeah, of course I wrote it on a docket and I'm assuming that because she filed that we're going to set the bond at 1,500.
What is it, a withdrawal?
Yeah.
Yeah, it's a waiver.
Yes.
Yeah,
If they're-
okay. On Patterson,
yes,
540.
Neosha Patterson.
Alicia Patterson, yeah. This was on last,
8810.
it's set for April 3rd.
Yes, I just noticed, I didn't get a chance, you ought to have read the probable cause before I got in here, Judge. But I noticed that, I don't think it meets the probable cause. I was gonna see if we could read it.
Yeah, absolutely. So, oh, you want to do a probable cause hearing?
Yes, we can.
Okay, absolutely. Please.
All right.
Did you get it? The cause number?
Yes, what is it? Criminal trespass, is that the one we're on?
Yes.
January 24th, 2025, Leo dispatched to apartment regarding family disturbance. Law enforcement officer made contact with complaining witness. Complaining witness and former dating relationship with defendant. Stated defendant has been banging on door of her apartment since 1/23/25.
Yeah.
Defendant did not make any threats or say anything besides banging on the front door. Law enforcement officer observed defendant moving around rear seats of complainant's motor vehicle. Complaining witness approached her motor vehicle, claimed ownership, and ID'd defendant as person inside. Complaining witness stated she had recently got a motor vehicle, had not let defendant borrow a motor vehicle or use it in any manner, and also stated that she secured all the seats. Defendant stated motor vehicle was already unlocked, and law enforcement officer did not observe signs of forced entry.
So just for trespass, you gotta either have been warned before, don't come around here, I don't want you here, or you're there and then you're told leave and you don't leave. So this doesn't fit either one of those. I mean, the door's already unlocked in the car. She's never been told not to go in this car, stay there. In fact, this is the lady that the complaining witness was here.
I remember that she was here.
They stayed.
I,
They have a bit of a history together as well. I think there was a prior where the complaining witness.
so the trespass is with regards to the car,
Yes.
okay? Did the complaining witness tell her to leave and she continued to stay? Or was there some kind of notice prior that, hey, you know, I don't want you here, or, hey, go through it one more time, will
She
you?
did not let her borrow it or use it in any manner.
She just took the car?
She was just in the car.
She was just in the car?
It was cold that night and she was trying to get in. And I know this isn't here, but the complaint witness told me that she didn't hear the initial call, initial knocks on the door. It was later when she reviewed the Ring camera that she saw her at the door since then, but she heard at the last few, the knocks or whatever. And that's when she reviewed the camera and then called the police. But I think it was more of a situation that she wasn't sure about her mental state. I know this isn't here either, but that's what she told me.
Right, but we can't get into the facts that are out because that's not fair to them, right? What
She
we,
shared with one